Can the states nullify the U.S. government? Let's find out. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we're going to be making a quasi-extension on our lecture that we gave regarding the Virginia legislature's recent attempts at a treacherous legislative act. We saw a common theme running throughout the comments talking about the Supremacy Clause in the U.S. Constitution and, of course, the 14th Amendment when addressing the comment I made at the start of the Virginia legislature lecture stating that the second article to the Bill of Rights in the U.S. Constitution doesn't apply. So before we go into any receipts, before we go into any historical backing, let's first do our due diligence and look at Article 6 of the U.S. Constitution, specifically Clause 2. That's the one referring to the Supremacy Clause. And of course, don't ever take my word for it. I encourage you all to go read all of Article 6. Article 6, Clause 2, it says, "This Constitution," referring to the U.S. Constitution, "and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." So that sounds pretty settled, conclusory, correct? It is on its face, and it is in principle. What we have to remember, and what I'm about to show you here with primary sources, not my opinion, but the arguments posed by the father of the U.S. Constitution and the author of the U.S. Declaration of Independence, is we have to always remember, why was the U.S. formed? Why was there ever a confederation, a relationship between the states? Well, we can actually quickly reference why in the preamble. It says, "We the people of the United States," which a very quick search can prove this to be true. The original preamble, what the Committee of Style during the Philadelphia Convention originally stated in the preamble, was "We the people of Rhode Island, New Jersey, Pennsylvania, Delaware, so on and so forth, all 13 of the states were listed in the preamble." And what Gouverneur Morris, who is the head chairman, per se, of the Committee of Style during the Philadelphia Convention, had said was it was shortened to "We the people of the United States" because the original was too cumbersome. That's it. So while it says "We the people of the United States," realistically, that's referring to we the people of each of the states are meeting to do what? In order to form a more perfect union, more perfect than what? Than the union, the League of Friendship that they had under the Articles of the Confederation. Why are they creating this union or making this more perfect union? To establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States. So how does that play in at all with Article 6, Section 2, the Supremacy Clause? The preamble is just as much part of the U.S. Constitution as all of the other 7 articles. Why? Because what's the point of a preamble? It's to explain the whole intent, the whole purpose of the foregoing document. So if, and this is not some conjured up personal belief, some novel legal theory, as I'm about to show you with primary source documents, with arguments posed by the founding generation, the Supremacy Clause also includes and weighs the preamble, which means if the states, again, the original parties to the U.S. Constitution, as made clear by the original preamble, the union between the states was to do, what is that? Five specific things: to establish justice, ensure domestic tranquility, provide common defense, promote general welfare, and secure the blessings of liberty to ourselves and our posterity. That is just as binding. That is just as supreme law as Articles 1 through 7, Amendments 1, well, Articles 1 through 10 in the Bill of Rights of the U.S. Constitution, and then, of course, Amendments 11 through 27 that were passed in later years. So just before there are any accusations of, Caleb, that's a novel theory, that's brand new, let's go to the founding generation. Now, this isn't the only part of the Federalist Papers that addresses this issue directly. There are a couple others, even ones by individuals like Alexander Hamilton, who would be the founder. He would probably be the most opposed founder, framer, to this argument that the states are the sole and supreme authority. You can reference, I have a list here real quick. We would read through all of them, but then this lecture would be about an hour long, and I don't think it warrants that long of a response. If y'all think it does, I will absolutely make an extension of this lecture, and we'll read through each of those Federalist Papers. But for your own reading, you can consult Federalist Paper 12, which was written by Mr. Hamilton. You can read number 32, which was written by Mr. Hamilton, if I remember correctly. You can read number 39, which was written by Mr. James Madison, and then, of course, number 46. Number 46 is written by Mr. James Madison, and if you're not familiar with Mr. James Madison, he is considered the father of the U.S. Constitution, and he's considered that because of his very active role in not only causing the Philadelphia Convention to come about, but how the debates during that convention were the results of that debate during the convention having come about. So we're going to read a few excerpts. Again, don't take my word for it. Go and read all of 46. Go and read those other Federalist Papers too. All of them share the exact same sentiment that I am espousing to you here. But if there is someone to consider about the sole or the true purpose of the U.S. Constitution, you can feel pretty safe in considering James Madison's, considering he is the father of the U.S. Constitution. So Federalist number 46, the influence of the state and federal governments compared. Madison says the adversaries, so the anti-federalists, and those papers are just as influential as the Federalist Papers because it was about a 40-60 split. 40 in favor of ratifying the U.S. Constitution, 60 not in favor. It's always important to remember that the Philadelphia Convention called 70 delegates. 55 showed up, only 35 voted to ratify. That is, what is that? Barely, no, that's, let's see, 70. So that's over a majority of the 55 delegates who showed up, and an exact 50-50 split for the delegates in total. Correction, it was 39 delegates who voted to ratify, not 35. So over a 50%. But the U.S. Constitution, especially when you read through the Anti-Federalist Papers, was not being viewed very favorably. So Madison says here, the adversaries, the Anti-Federalists of the Constitution seem to have lost sight of the people altogether in their reasonings on this subject, and to have viewed these difficult establishments not only as mutual rivals and enemies, but as uncontrolled by any common superior in their efforts to usurp the authorities of each other. These gentlemen must here be reminded of their error. They must be told that the ultimate authority, wherever the derivative may be found, resides in the people alone, and that it will not depend merely on the comparative ambition or address of the different governments, whether either or which of them will be able to enlarge its sphere or jurisdiction at the expense of the other. Truth, no less than decency, requires that the event in every case should be supposed to depend on the sentiments and sanction of their common constituents, the people. Many considerations besides those suggested on a former occasion seem to place it beyond doubt that the first and most natural attachment of the people will be to the governments of their respective states. Further down, he says, if, therefore, as has been elsewhere remarked, the people should in future become more partial to the federal than to the state governments, the change can only result from such manifest and irresistible proofs of a better administration, as will overcome all their antecedent propensities. Antecedent, taking place before. So originally, the people should be favoring their antecedent propensities, which inclines them to trust their state governments, to rely on their state governments more than this new federal government. Further, he says the remaining points on which I propose to compare the federal and state governments are the disposition and the faculty they may respectively possess to resist and frustrate the measures of each other. So he's talking about checks and balances, not between the three branches of the U.S. government, but between the state governments and the U.S. government. He's talking about nullification. He's talking about resistance. It says here, it has been already proved that the members of the federal will be more dependent on the members of the state governments, and the latter will be on the former. Did that come true? No. It has appeared also that the prepossessions of the people on whom both will depend will be more on the side of the state governments than of the federal government. So far as the disposition of each towards the other may be influenced by these causes, the state governments must clearly have the advantage. Couldn't say it clearer. The prepossessions which the members themselves will carry into the federal government will generally be favorable to the states, whilst it will rarely happen that the members of the state governments will carry into the public councils a bias in favor of the general government. A local spirit will infallibly prevail much more in the members of Congress than a national spirit will prevail in the legislatures of the particular states. Further down he goes, I mean not by these reflections to insinuate that the new federal government will not embrace a more enlarged plan of policy than the existing government, the Articles of the Confederation, may have pursued, much less that its views will be as confined as those of the state legislatures. Both, only that it will partake sufficiently of the spirit of both to be disinclined to invade the rights of the individual states or the prerogatives of their governments. That speaks very clearly for itself, that if there is any question about powers that are attempted to be exercised by the U.S. government that may or may not be trampling on the powers of the state governments, that the power of the state government is to be preferred. Further, he says the motives on the part of the state governments to augment their prerogatives by defalcations from the federal government will be overruled by no reciprocal predispositions in the members. Were it admitted, however, that the federal government may feel an equal disposition with the state governments to extend its power beyond the due limits, the latter, the state governments, would still have the advantage in the means of defeating such encroachments. State sovereignty, state superiority. The states determine ultimately what is and what isn't constitutional. That is from the mouth of the father of the U.S. Constitution. If an act of a particular state, though unfriendly to the national government, be generally popular in that state, and should not too grossly violate the oaths of the state officers, it is executed immediately, and, of course, by means on the spot and depending on the state alone. The only refuge left for those who prophesy the downfall of the state governments is the visionary supposition that the federal government may previously accumulate a military force for the projects of ambition. I know, such a crazy idea, right? Poor Madison was so naive. Let's read that again. This time I won't start chuckling midway through. The only refuge left. So he's saying these people who are against the U.S. Constitution because those adversaries of the U.S. Constitution believe the federal government will inevitably overthrow the state governments. He says the only visionary supposition that the federal government may previously accumulate, or that the federal government will overthrow the state governments, is that the federal government may previously accumulate a military force for the projects of ambition. Further, he says, let a regular army fully equal to the resources of the country be formed, and let it be entirely at the devotion of the federal government. So he's playing a hypothetical. Still, it would not be going too far to say that the state governments with the people on their side would be able to repel the danger. The highest number to which, according to the best computation, a standing army can be carried in any country does not exceed 1/100th part of the whole number of souls, or 1/25th part of able to arms. That's a very dangerous statement. He's not only saying the state governments, if the federal government were to try to overthrow them, the state governments would not only be able, but are duty-bound by arms to displace and to negate any sort of encroachments by the federal government. Now, I did highlight a couple other sections down this way, but let's actually read up the summary. He does a pretty good job in the end here. He goes on summing up the considerations stated in the last paper. They seem to amount to the most convincing evidence that the powers proposed to be lodged in the federal government are as little formidable to those reserved to the individual states, as they are indispensably necessary to accomplish the purposes of the Union, and that all those alarms which have been sounded of a meditated and consequential annihilation of the state governments must, on the most favorable interpretation, be ascribed to the chimerical fears of the authors of them. Okay, well, Caleb, this is just an idea from one guy. Okay, I'll even grant that. I'll grant that James Madison was just one guy. Alexander Hamilton making similar concessions in the same Federalist Papers. That's just two guys. Has this principle been put into practice? This idea that the state governments are the ultimate arbiters of what is and what isn't constitutional. It absolutely has. And it was first done by Mr. Thomas Jefferson, author of the U.S. Declaration of Independence. And again, these aren't singular, unpopular sentiments. This was the majority understanding when the U.S. Constitution was being considered for ratification. So Thomas Jefferson, in response to the Alien and Sedition Acts, wrote the Kentucky Resolution of 1798, in which he says this: resolved that the several states composing the United States of America, notice, he says the states, not the people, that the several states composing the United States of America are not united on the principle of unlimited submission to their general government. So what does that mean? That means the Supremacy Clause is binding only, and it says it in itself, is binding only when the laws being enacted under it are in pursuance of the U.S. Constitution. A very easy way to remember this key principle is to remind yourself which governing body was formed first, the states or the U.S. It was the states. Therefore, the U.S., as declared in the preamble of the U.S. Constitution, is formed for the benefit of the states, not vice versa. And just as Madison said there in that Federalist paper, the powers of the states are nearly infinite, while the powers of the U.S. government are very few, finite, limited, and enumerated. So let's get back to Jefferson and the Kentucky Resolution of 1798. On the principle of unlimited submission to their general government, are not united on that principle, but that by a compact, perfect synonym for contract, under the style and title of a Constitution for the United States and of amendments thereto, they constituted a general government for special purposes, not infinite, special, delegated to that government certain definite powers, reserving each state to itself the residuary massive right to their own self-government, and that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. That to this compact each state acceded as a state, and is an integral part, its co-states forming as to itself the other party. Not the people, the states. Again, this is the author of the U.S. Declaration of Independence. If their opinions don't matter, Thomas Jefferson's, James Madison's, if their opinions don't matter, I'm not sure any of the opinions from the founding generation matter. Well, Caleb, that's an appeal to authority. The argument you will hear probably most often from any court is the desire to access the interpretation or the legislative intent of laws and constitutions. These people, Mr. Madison, Thomas Jefferson, overtly declare their intent with the U.S. Constitution. We don't have to speculate. We don't have to try to play these mental gymnastics and mind games. We have the transcripts from the Philadelphia Convention. We have the father of the U.S. Constitution explaining verbatim what the convention meant to do with that document. Why not apply their understanding instead of some sort of speculative conjuration made up by modern historians who are just activists? So let's read on with Mr. Jefferson. Since that would have, oh, wait, where'd it go? Its co-states forming as to itself the other party, the states, not the people, are the other party. That the government created by this compact was not made for the exclusive or final judgment of the extent of the powers delegated to itself. That's yet another thing addressed in the Federalist Papers. I think it was by Hamilton, that if you allow the federal government to determine what is and what isn't constitutional, then it is going to define infinite boundaries to be considered as constitutional exercises of its authority. Therefore, the states have to have that check against the U.S. government. Since that would have made its discretion and not the U.S. Constitution almost verbatim what Hamilton said, the measure of its powers. Let's read that again. the other party, that the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion, and not the U.S. Constitution, the measure of its powers, but that, as in all other cases of compact among powers having no common judge, each party has an equal right to judge for itself, as well of infractions as of the mode and measures of redress. Further down in the second clause, resolved, that it is true as a general principle, and is also expressly declared by one of the amendments to the constitutions, that, quote, the powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively, or to the people. I'm pretty sure that's just a recitation of what's in Article 10 to the Bill of Rights. Let's see here. There's Article 9. Nope, that was not Article 9. What am I thinking? Here we go. The powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively, or to the people. Let's scroll down a little bit further. It comes to a conclusion. If I can find it. I thought I highlighted it. Well, we'll just keep reading through these sections that I've highlighted, see what he's got to say. So in the 7th clause, he says, resolved that the construction applied by the general government to those parts of the Constitution of the United States which delegate to Congress a power to lay and collect taxes, duties, imports, and excises, to pay the debts and provide for the common defense and general welfare of the United States, and, quote, to make all laws which shall be necessary and proper for carrying into execution. Yes, Mr. Madison also addressed the necessary and proper clause. No, I'm sure it comes as a surprise. It does not give the U.S. government a carte blanche permission slip to enact whatever they think is necessary and proper. That's the interpretation, the perversion that the Supreme Court has upheld for many, many decades, but it is not the one that the U.S. Constitution has, nor the authors of the U.S. Constitution even imply that it gives. For carrying into execution the powers vested by the Constitution in the government of the United States or in any department or officer thereof, goes to the destruction of all limits prescribed to their powers by the Constitution. That word's meant by the instrument to be subsidiary only to the execution of limited powers. It's almost verbatim what James Madison said. Ought not to be so construed as themselves to give unlimited powers, nor a part to be so taken as to destroy the whole residue of that instrument. That's almost verbatim what Madison argued in the Federalist Papers. But where powers, so this is a brief summary, and again, don't take my word for it, go and read this document entirely for yourself. He says here, but where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy. It's not taken out of context. You can read through it right here. He's discussing how when the federal government goes awry, the only check as to the infinite limits the federal government believes it has, pursuant to the necessary and proper clause, the only check is an act of nullification. By whom? The U.S. Congress? No. The U.S. Supreme Court? No. The U.S. President? No. The states. And then he recites Latin legal maximum casus non fuderis. Later on, coming closer to a summary here, in this last clause, well, second to last clause, he says, and live under one, let's just go ahead and read this whole sentence, that this would be to surrender the form of government we have chosen. Does he give more context? Yeah, we'll start from here. I don't know why I highlighted just this last part. I was probably reading through it. Never mind. I won't blabber on. That they will concur with this Commonwealth in considering the said acts as so palpably against the Constitution as to amount to an undisguised declaration that that compact is not meant to be the measure of the powers of the general government, but that it will proceed in the exercise over these states of all powers whatsoever, that they will view this as seizing the rights of the states and consolidating them in the hands of the general government, with a power assumed to bind the states, not merely as the cases made federal, causes foederis, but in all cases whatsoever by laws made not with their consent, but by others against their consent, that this would be to surrender the form of government we have chosen, and live under one deriving its powers from its own will, and not from our authority, and that the co-states, recurring to their natural right in cases not made federal, will concur in declaring these acts void and of no force, and will each take measures of its own for providing that neither these acts nor any others of the general government not plainly and intentionally authorized by the Constitution shall be exercised within their respective territories. Caleb, that's just Thomas Jefferson saying that. Are you sure? Because James Madison wrote something very similar. He went and wrote the Virginia Resolutions of 1798. Here's a bit of historical context provided by the source Founders Online. We're going to scroll down to the actual document, which says this: in the House of Delegates, Friday, December 21st, 1798. Resolved that the General Assembly of Virginia doth unequivocally express a firm resolution to maintain and defend the Constitution of the United States and the Constitution of this state against every aggression, either foreign or domestic, and that they will support the government of the United States in all measures warranted by the former. That this assembly most solemnly declares a warm attachment to the Union of the States. So does Virginia, yeah, this is the Virginia resolution, yeah. Does the Virginia delegation, does this Virginia conference hate the U.S. Constitution? Do they even hate the Union of the States? No, in fact, they're trying their best to uphold it. It says here that this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact, the U.S. Constitution, to which the states are parties. Again, father of the U.S. Constitution. Who are the parties to the U.S. Constitution? Is it the U.S. government and the people? No, it's the U.S. government and the states, as limited by the plain sense and intention of the instrument constituting that compact, as no farther valid than they are authorized by the grants enumerated in that compact, and that in case of a deliberate, palpable, and dangerous exercise of others' powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of the evil and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them. He couldn't have said it more clearly. Well, he probably could have, but then you wouldn't get this nice vocabulary. The states are the ones responsible, as he said, duty bound. Well, I'm losing it, but duty bound to make sure any encroachments beyond the U.S. Constitution's confines are checked, are kept restrained, are arrested from further progress. Further, he says that the General Assembly doth particularly protest against the palpable and alarming infractions of the Constitution in the two late cases of the Alien and Sedition Acts, passed at the last session of Congress, the first of which exercises a power nowhere delegated to the federal government, and which, by uniting legislative and judicial powers to those of executive, subverts the general principles of free government, as well as the particular organization and positive provisions of the federal Constitution, and the other of which acts exercises in like manner a power not delegated by the Constitution, but on the contrary expressly and positively forbidden by one of the amendments thereto, a power which more than any other ought to produce universal alarm, because it is leveled against that right of freely examining public characters and measures, and of free communication among the people thereon, which has ever been justly deemed the only effectual guardian of every right. That this state, having by its convention which ratified the federal Constitution expressly declared, quote, that among other essential rights, the liberty of conscience and of the press cannot be canceled, abridged, restrained, or modified by any authority of the United States, and from its extreme anxiety to guard these rights from every possible attack of sophistry or ambition, having with other states recommend an amendment for that purpose, which amendment was in due time annexed to the Constitution, it would mark a reproachful inconsistency and criminal degeneracy if an indifference were now shown to the most palpable violation of one of the rights thus declared and secured, and to the establishment of a precedent which may be fatal to the other. We can definitely go through the rest of this. I don't think it's really warranted. He summarized it very well in this paragraph. What about any other examples? The Kentucky Resolution of 1799 showed a reaffirmation of the principles stated in 1798. The 1799 resolution was also written by Mr. Thomas Jefferson, again, author of the U.S. Declaration of Independence. And he says, to again enter the field of argument and attempt more fully or forcibly to expose the unconstitutionality of those obnoxious laws would, it is apprehended, be as unnecessary as unavailing. So even if the federal government says, actually, no, the states don't get to nullify, Thomas Jefferson would then say, actually, because of how obnoxious, because of how unavailing it would be to continue arguing with this federal government, with this government who is clearly violating its powers, overstepping its granted authorities, there's no point. It would be unnecessary to reiterate what is already self-evident. Faithful to the true principles of the federal union, notice it doesn't say federal state, federal country, federal nation, federal union, unconscious of any designs to disturb the harmony of that union, the anxious only to escape the fangs of despotism, the good people of this commonwealth are regardless of censure or calumniation. Resolved that this commonwealth considers the federal union upon the terms and for the purposes specified in the late compact as conducive to the liberty and happiness of the several states. It doesn't say the people, the states. That it does now unequivocally declare its attachment to the union and to that compact, agreeable to its obvious and real intention, and will be among the last to seek its dissolution. So no, these are not insurrectionists, these are not criminals, these are not secessionists, these are people looking to uphold the terms of the U.S. Constitution, even when the U.S. government isn't wanting to. That if those who administer the general government be permitted to transgress the limits fixed by that compact by a total disregard to the special delegations of power therein contained, annihilated of the state governments, and the erection upon their ruins of a general consolidated government will be the inevitable consequence. And finally, in order that no pretexts or arguments may be drawn from a supposed acquiescence on the part of this commonwealth in the constitutionality of those laws, and be thereby used as precedents for similar future violations or of federal compact, this commonwealth does now enter against them its solemn protest. Well, Caleb, this was just an idea that was shared by the Anti-Federalists, even though James Madison called himself a Federalist, even wrote in the Federalist Papers. Clearly, he was more of an anti-Federalist disposition. And Thomas Jefferson, even though he wrote the Declaration of Independence, was just kind of a standoff guy. This is clearly just a anti-Federalist favored position. Are you so sure? If so, I would suggest you look into the Hartford Convention of 1814, in which the Federalist Party, a bunch of New England states, met together to form what essentially became a nullification of the actions and powers that were being exercised in light of the War of 1812. They went on to suppose a whole bunch of amendments to the U.S. Constitution and were implying, suggesting, and declaring that they would not be obeying the ordinances, the exercises that the U.S. government was taking in light of the War of 1812. No, this was not an anti-federalist exclusive position, principle, or belief. It was the understanding among the states we're going to be joining and be party of the Union. Federalists, of course, being the party most in favor of centralizing power to the U.S. government. If Article 6, the Supremacy Clause, truly meant that the U.S. government could go unchecked by the states, why would the Federalist Party at all question or suggest any sort of reform to the U.S. government and its powers? The point being, it wasn't just an anti-Federalist position, it was the understood position when the states went to consider the U.S. Constitution that they are the supreme authority, that they are the original jurisdiction, that they have the final say. Why? Because the U.S. was formed for their benefit, not vice versa. So if at any time a state feels it's no longer benefited by the U.S., well, then the U.S. is no longer serving its sole purpose. Thus, the state has no reason to stay in the U.S. What about another time? How about Mr. John C. Calhoun, Vice President of the United States under Andrew Jackson, if I remember correctly, wrote his exposition and protest for 1828. This was in light of the tariff abominations. He says in December 19th, 1828, the Senate and House of Representatives of South Carolina now met and sitting in General Assembly to the Honorable William Smith and the Honorable Robert Y. Hayne, their representatives in the Senate of the United States, do in the name and on behalf of the good people of the said Commonwealth solemnly protest against the system of protecting duties lately adopted by the federal government for the following reasons. So he gives 1, 2, 3, 4, 5, 6, 7, and 8 reasons. What format does that follow? That follows a very similar format to the U.S. Declaration of Independence. They start off with saying how this meeting, how this document is being written up, how it's being considered. They express grievances. They conclude, well, they also show the basis for their redress, then they conclude with their action, just as the U.S. Declaration of Independence did. So he concludes, and he says, deeply impressed with these considerations, the representatives of the good people of this Commonwealth, anxiously desiring to live in peace with their fellow citizens, and to do all that in them lies to preserve and perpetuate the union of the states and the liberties of which it is the surest pledge, but feeling it to be their bounden duty to expose and to resist all encroachments upon the true spirit of the Constitution, lest an apparent acquiescence in the system of protecting duties should be drawn into precedent, do in the name of the Commonwealth of South Carolina claim to enter upon the journals of the U.S. Senate their protest against it as unconstitutional, oppressive, and unjust. Jackson had a few words to say about this, none of which are found in the U.S. Constitution or rooted in the U.S. Constitution. So he remarks back, and in these first few paragraphs details what the protest is saying, and he says this, and whereas the said ordinance, so he's talking about the exposition and protest, whereas the said ordinance prescribes to the people of South Carolina a course of conduct in direct violation of their duty as citizens of the United States, whoa, there's already a violation. What did James Madison, Thomas Jefferson, even the Federalists admit? The U.S. Constitution isn't a contract between the citizens, isn't a contract between the people and the U.S. government. It's a contract between the U.S. government and the states. There's no such thing as a citizen of the United States. You can be a citizen of your state, and your state is a member of the U.S. If that's kind of causing conflict with you, consider this. Would you say you're a citizen of the United Nations? Because your union, the U.S., is a member to the United Nations, just like your state is a member to the United States. So if you consider that someone can be a citizen of the United States, are you willing to admit that you're also a citizen of the United Nations, since the U.S. is a member of the United Nations? Obviously not, because, at least in political thought, you can't be a citizen of a union. You can be a citizen of a nation, you can be a citizen of a country and of a state, but you can't be a citizen of a union, which is why it's so important to remember that the U.S. Constitution is a contract between the states and the U.S. government, not the U.S. government and the people. So that's already an unconstitutional statement. He goes on to say, contrary to the laws of their country, subversive of its constitution, every single one of those proclamations said directly to the contrary. They are not looking to subvert. They are not looking to in any way disrupt or pervert the U.S. Constitution. They're looking to do the exact opposite, to maintain and preserve it. And having for its object the instruction of the Union, that Union which, coeval with our political existence, led our fathers without any other ties to unite them than those of patriotism and common cause, through the sanguinary struggle to a glorious independence, that sacred Union. Keep focusing on that. Pay close attention to that. He is honing in on a sacred Union. The Union is not sacred. The states, if anything is sacred, are what is sacred. The states formed the Union for their benefit, not vice versa. Jackson is prioritizing the Union over the states. That is not the purpose of the Union, as stated in the preamble and as made very overtly clear by the most influential founders, such as Thomas Jefferson and James Madison, and then, of course, conceded also by those who disagreed in part with that idea. That sacred Union, hitherto inviolate, it is not inviolate, as admitted in Article 10 to the Bill of Rights of the U.S. Constitution, which, perfected by our happy Constitution, has brought us, by the favor of heaven, to a state of prosperity at home and high consideration abroad, rarely, if ever, equaled in the history of nations, to preserve this bond of our political existence from destruction, to maintain inviolate this state of national honor and prosperity, and to justify the confidence my fellow citizens have reposed in me, I, Andrew Jackson, President of the United States, have thought proper to issue this my proclamation. Does anywhere in Article 2 of the U.S. Constitution give Jackson, the President, any authority to do that? No. If he has any sort of redresses, if he has any sort of concerns, he gets to state it at the State of the Union address. He does not get to make these silly proclamations. These are acts akin to legislative declarations, to legislative opinions. You, as the executive, are not responsible for doing that. You are not given that power in any form or fashion according to Article 2. This, my proclamation, stating my views of the Constitution and laws applicable to the measures adopted by the Convention of South Carolina. You also don't get to do that. And to the reasons they have put forth to sustain them, declaring the course which duty will require me to pursue, and appealing to the understanding and patriotism of the people, warn them of the consequences. So you're going to comply with these unconstitutional actions, or else I'm going to send arms after you. I'm going to point arms at you. I'm going to make you comply. Does that sound like a free government? No, which is exactly why the founding generation didn't give the executive the power that Andrew Jackson is exercising here. Warn them of the consequences, so he's threatening the states that must inevitably result from an observance of the dictates of the convention. Strict duty would require of me nothing more, actually it would, nothing more than the exercise of those powers with which I am now. None of those powers, including what you're doing right now, or may hereafter be invested for preserving the Union. Your job is not to preserve the Union. Your job is very directly listed in Article 2. But the imposing aspect which opposition has assumed in this case by clothing itself with state authority, clothing itself, that's the legitimate principle. State authority is the true authority, at least in terms of the U.S. Constitution, and the deep interest which the people of the United States must all feel in preventing a resort to stronger measures. The ordinance is founded not on the indefeasible right of resisting acts which are plainly unconstitutional and too oppressive to be endured, but on the strange position that any one state may not only declare an act of Congress void, but prohibit its execution. As we've already seen in the Federalist Papers from James Madison, even conceded by folks like Alexander Hamilton, that is not a strange idea, that is the idea. That is the principle. Because just as Jefferson said, just as Madison said, just as Hamilton conceded, if you allow the U.S. government to define the scope of its powers, if you take that to be the interpretation of Article 6, which it is very clearly not, then the federal government will have infinite powers, and the states can do nothing about it. That is clearly, verbatim, denounced by the founding generation. It is true, they add, oh wait, I skipped a few lines, but prohibit its execution, that they may do this consistently with the Constitution, that the true construction of that instrument permits a state to retain its place in the Union, and yet be bound by no other of its laws than those it may choose to consider as constitutional. That is the idea. It is true, they add, that to justify this abrogation of a law, it must be palpably contrary to the Constitution, but it is evident that to give the right of resisting laws of that description, coupled with the uncontrolled right to decide what laws deserve that character, that character is to give the power of resisting all laws. Yes, and if you don't like it, Jackson, you don't like what a free government entails. Prefer dangerous liberty over comfortable slavery, over comfortable safety. If you don't like which laws a state nullifies or enforces, go to a different state. That's the point of allowing and having the states retain their own governments. If the founding generation truly wanted to make strange this idea that Jackson believes to be strange, they wouldn't have let the states keep their individual governments. No, Jackson, the nullifiers are not the one propagating this strange idea. You are the one propagating the strange idea. Madison agrees, Hamilton conceded, Jefferson agrees. And if those two individuals declare that that's the true intent, you can feel pretty safe, pretty confident in that having been the true intent. And of course, you don't have to take their word for it, because just about everywhere you look, even at some points with people like John Jay, the true understanding, the purpose of the Union was to benefit the states. Therefore, they are the ultimate arbiter. They are the ultimate determiner of what is and what isn't constitutional. Okay, I think we've gone over the Supremacy Clause thoroughly enough. I've already gone into about the hour mark. I didn't mean to go that long, but hopefully that explanation is thorough enough to dispel any sort of misinterpretations about Article 6 overthrowing state authority. But in short, no, the states formed the Union for their benefit, not vice versa. Article 6 restrains the actions of the U.S. government, not the states. Caleb, that's a personal interpretation. And please reread through those sources, because the father of the U.S. Constitution agrees with me, and the author of the U.S. Declaration of Independence, Thomas Jefferson, agrees with me. And you can look at other authors like George Mason, John Dickinson, John DeWitt. You can look at even John Jay at some points, Patrick Henry, the gentleman who said, give me liberty or give me death. All of these different founders are where we derive that principle. And if we consider at all what the intent is supposed to be, look at their explicit declarations. So that way you don't have to speculate about their intent. So, in short, no. The Article 6 in the U.S. Constitution does not overthrow state authority. Now let's address Amendment 14 and the concerns surrounding Amendment 14. First, just like we did with Article 6, let's read exactly what Amendment 14 says, and then we'll discuss how it's non-binding, how it doesn't apply. So here's Amendment 14. It has 5 sections. 5 sections in total. Section 1 says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Politically speaking, legally speaking, that can't be true. Because if you can be a citizen of the United States, a union, it's not a nation, it's not a country, it's not a state, it's a union, a confederacy, as recognized by folks even like Jackson. If you can be a citizen of a union, congratulations, you're also a citizen of the United Nations. You're now a United Nationite, a citizen of the globe, because the U.S. is a member of the United Nations. It's absurd to suppose that you can be a citizen of the Union, which is why in those documents, I need to drink some water. In those primary documents that we just read through, Jefferson and Madison made overtly clear and made certain they referred to the states whenever they were discussing the parties of the U.S. Constitution. It's not the U.S. government and the people, it's the U.S. government and the states. So no, you cannot be a citizen of the United States. You can't be a citizen of a union. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion, other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. How do you define insurrection? How do you define rebellion? Neither of which are defined in the U.S. Constitution. In fact, there is only one crime defined in the U.S. Constitution, and James Madison provides a very sound argument as to why treason is the only defined crime in the U.S. Constitution. He says basically treason is the crime levied most often by tyrants trying to silence their dissent, their opposition. So in Article 3, it defines treason, the only crime defined in the U.S. Constitution. None of that definition includes insurrection or rebellion. So how are you going to enforce, how are you going to punish, how are you going to convict someone of insurrection and rebellion if you're not defining the legal parameters for what insurrection or rebellion are? They're just synonyms for treason. Not perfect synonyms, okay? They're synonyms. Section 4, The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. Section 5, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Excellent. So we can go into two different types of arguments. I'm going to save the other argument because this is already getting to be a very lengthy lecture. I did not mean for this to go on this long. If you want that other argument, just let me know in the comments. And again, I'll provide a part 2 to this lecture. We can already declare, recognize, the 14th Amendment was not ratified. It was not adopted in pursuance of Article 5. So I should have gone over this before we switched to the memorandum. But let's look at Article 5 in the U.S. Constitution. Article 5 is the article which provides the process, the procedure for amending the U.S. Constitution. And it says the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Okay. So there is our process. There is our procedure. In order for Article 14, in order for Amendment 14 to be considered legitimate, constitutional, and binding, it has to comply with Article 5. Otherwise, it isn't constitutionally ratified. There's a legal argument, a legal case to be made outside of this formal acknowledgement that the 14th Amendment did not comply with Article 5 to prove it was not ratified constitutionally. But we don't even have to consider that legal argument. If you want to hear it, again, I'll gladly provide a part 2 to this lecture. It is formally acknowledged by the Solicitor General in 1913 in his memorandum on the 16th Amendment. He provided this, I think it was to the executive, making the argument that even though the 16th Amendment skirts some parts of the procedure as prescribed in Article 5 of the U.S. Constitution, it doesn't matter. It can still be ratified. Why? Because the 14th Amendment also broke the rules of Article 5. He says, in the resolutions of the state legislatures on file in the department ratifying the 14th Amendment to the Constitution, there are many errors of punctuation, capitalization, and wording. Some of the errors in wording being substantial errors. So when the U.S. government proposes to the states an amendment to the Constitution, can the state then go and change up the amendment however they wish, resubmit it to Congress, and Congress say, well, they submitted something back, we can ratify whatever we sent them out? No. That is not part of the procedure in Article 5. It has to be one for one, direct copy and paste, the exact same thing the U.S. Congress propagated out to the state legislatures for consideration. It cannot have one tittle out of place. It cannot have one comma out of place. It has to be the exact same thing. It's so important because even one comma can change the meaning of a clause, can change the meaning of a provision. That's what the Solicitor General is saying here. There were errors. They violated the terms and the procedures required in Article 5 of the U.S. Constitution. This isn't some crazy conjuration that we're making up. This is a federally, formally acknowledged recognition that the 14th Amendment was not ratified. It did not obey the requirements of Article 5. And it's because of this violation of the rules. Bummer, I skipped over it. Where is it? There's another section I highlighted in here. Let's see if I can find it. There it is. And he goes, because the 14th Amendment circumvented the rules and was still ratified, so too can the 16th Amendment. As by announcing the ratification of the 14th Amendment, the executive branch of the government ruled that these errors were immaterial. Does Article 2 suggest anything of that extent of power? Not remotely. That these errors were immaterial to the adoption of the amendment, and further, as this amendment has been repeatedly before the courts and has been by them enforced, so precedent overrides proper procedure and the Constitution itself, and has been by them enforced, it is clear that the procedure in ratifying that amendment constitutes on this point a precedent, which may be properly followed in proclaiming the adoption of the present amendment. That is to say that the Secretary of State may disregard the errors, disregard the errors of wording, substantial wording mistakes, restructures of the amendment, may disregard the errors contained in the certified copies of the resolutions of legislatures acting affirmatively on the proposed amendment. No. Just because you broke the rules once does not mean you get to break the rules again. Breaking the rules once is not precedence for breaking the rules again. This is not some crazy conjuration that we at the Calhoun School of Law are making up. That is a formal recognition by a federal office. The 14th Amendment was not ratified. It did not comply with the requirements in Article 5 of the U.S. Constitution, thus it did not follow Constitution. Excuse me, I really need to get a glass of water. It does not follow the requirements to be constitutionally binding, thus it is not law. It is not a legitimate amendment. Further, you can't be a citizen of a union. And if you can, if you're saying, well, Caleb, that's bogus, congratulations, go ahead and announce your United Nationite citizenship. Go ahead and announce your Citizen of the Globe title. Congratulations. Point being, in total summary, for both the Supremacy Clause and the 14th Amendment, the Supremacy Clause limits the U.S. government. According to the most influential and the vast majority of the founding generation, virtually anywhere you look in their primary sources, they say the states are the supreme authority. They ultimately determine what is and what isn't constitutional. That is made overtly clear by the Virginia and Kentucky resolutions of 1798, written by James Madison, father of the U.S. Constitution, and Thomas Jefferson, author of the U.S. Declaration of Independence. The states are the supreme authority on what is and what isn't constitutional. The 14th Amendment, it was not ratified, and you can't be a citizen of a union. You're a citizen of your state, and your state is a member to the union. So if y'all have any further questions, if y'all would like me to provide a part 2 detailing that exact argument as to how the 14th Amendment, irregardless of this formal acknowledgement, how the 14th Amendment was supposedly not ratified, I'll gladly provide that to you. If you have a legal topic you'd like me to cover in a future lecture, also post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.